Hello and welcome. Thank you for watching our presentation today. The law offices of McLaughlin & Associates and McLaughlin Mediation and Consulting focus on helping small to mid-sized businesses grow and thrive. You started your business because of your passion. Let us help you with that vision. We offer a variety of legal and human resources services. Check out our website for more details at www.ma-lawpc.com. And now, on to our presentation.
Okay, so the agenda is going to be, and we gave you guys printouts. You don't have to follow this. It's just so if you want to take notes in that, so it'll all be here. So we're going to start off with common law versus statutory rights. There's a difference between what you just sort of get by virtue of the fact of the laws and then statutory rights. We're going to talk about statutory copyright and trademark. That's where all your protections come from under the laws. Then we're going to talk about trade secrets, confidential information, and non-competes. I do this by design. I'm actually starting with the strongest protections to the weakest protections. So oddly enough, you see non-competes as the last. That's what people rely upon. But if you don't have the stuff that goes before there, a lot of times there's very little to protect. But I'm going to talk to you a little bit about that one as well. The little tent that we gave you is something we put together. It has all the presentations that we have done and that we're going to do in the future. So hold on to that. That'll be the dates coming up. If you know anybody is interested, invite them to come, and so we'd appreciate that. At the end of this year, when we finish this group, we're going to probably do some of it online, so we may have some remote learning on this, and then we'll have some more new content for next year as well. So first thing I want to talk about is what's the difference between common law and statutory. So you may or may not have ever heard the word common law. So what are my common law rights? It actually comes from the English common law. So when we came to this country, unless you were a Native American, you weren't born here, right? Your ancestors didn't come from here. And so therefore, the original settlers came from England. They brought their laws with them. That's the common law. Those are the typical laws you think about. So your tort laws, you get into an auto accident, you get an injury, your contract rights, what rights do you have under a contract? There's actually common law, copyright, and trademark, right? So when back, in the 1700s, they had artwork, right? We know of all the medium, so there were people writing books. There were trade names of businesses. All those things existed under the common law. So and we're going to talk a little bit about that, but there are these inherent built-in rights. But because they come from the common law, they're really kind of the most basic low-level rights that you can have. It's sort of like when someone says, "You violated my rights," and they don't really have anything else. Technically they did, but you sort of kind of throw yourself on the mercy of a court. And that's not a good place to be in a business world because, especially when we talk about trade secrets, the types of things we're talking about, there's money behind them, but there's reputation and there's some other things that go behind it that you can't just go to a court and say, well, you really haven't lost anything, so therefore take a couple $1,000s. And if you've ever been through the court system, that's kind of the attitude that you'll get, and that's not a good feeling to have. On the bottom, we have what are called statutory rights. So a lot of the major laws that we have, not just in the intellectual property area that we're talking about, but even employment. So every major law that we have has a statute that goes with it. So it's either at the state level or many of them are at the federal level. So the ones that we're going to be talking about today are federal statutes. They apply across the country. So when you get a federal trademark, for example, it's a federal law, so it gives you protections in the country as opposed to the state of Illinois or New York or somewhere like that. Okay. The one thing that we are going to focus on that's Illinois specific is the Illinois Trade Secrets Act. It gives you a ton of protection, and it's going to play in a lot when we talk about things like non-competes and the basic protections you need in your business. So let's talk about copyright. So copyright, the common law understanding of copyright and what's at the federal level in the U.S. Copyright Act are the same, but it's the protections that you get under the federal act that are important. So let's just talk a little bit about what's copyright. So copyrights deal with artwork, books, designs, music. Anything that you create falls under copyright. So if you think about the obvious ones here, for example, that painting that's on a wall, all right? The book that I would write. So if I'm an author, for example, those are kind of typical things we think about. but they are actually broader than that. So when I write a manual for my business, that falls under copyright. That's because of the way I organize that. Those are things that people forget about. Let's say I have products and I put together a nice manual. It could be online or it could be I provide it to my customers. That's copyright, because even though the isolated products themselves may not be a copyright, you may not have a right to, say, for example, say you're making cars and you have an engine, right? The engine itself isn't, but the way that you lay it out, your colors, those types of things are protectable. And your competitors look to that, right? Because they don't want to create their own, especially if it's digital. It's easy to rip things off and they'll take it. So the common law gives you those rights in it, but the problem is it's because you say so. And what we're going to talk about in a little bit is how do you know who's got the superior rights? If you've never done anything and no one knows that your thing exists until it shows up on a website or you send it to a competitor, and then all of a sudden they copy yours, the very first question is going to be like, well, no, they copied me. I mean, that happens all the time. People are not, if they're going to steal your stuff, they're not going to be afraid to lie about it, okay? So the issue is, first of all, understanding the content, which we can grasp, but it's also how do you protect it. So it's the first one who created it. Now, in copyright world, that's a complicated thing. It means the one who created it. It means the artist. It means the writer. So if you hire somebody to create say a magazine layout, or to create a manual of some sort, they're technically the author of it. If you let them create that and you had no contracts tied to that and you did nothing more, arguably they actually own the copyright. They could theoretically go and copyright that out from under you. So that's where we talk about work for hire. So if you ever look in contracts, and almost every contract will have a paragraph that talks about work for hire, it exists specifically because whenever you're doing work, so even things like software development, right, that falls under copyright. You're developing things. It actually falls under patent as well, but sometimes the design elements of it, it will say, you understand under this contract, you are doing this as a work for hire. You are doing this as me, so that even though you're the creator, contractually, I'm the creator. I get to now register the trademark in my name and you get nothing from it. And so one of the issues that I find people do is they will hire somebody on to do the work, especially like a newer company, and then they want to save a couple bucks here, and they get some young kid who's out of college to help them out. And they don't put contracts together. I don't want to make it super complicated. And then the very thing that they do takes off. I could be wrong on this, but I'm pretty sure, I think the Nike swoosh was, if you guys know the story, I believe it was someone just kind of randomly got paid $1,000 for it. And of course, that's a multi-billion-dollar symbol, right? Those things happen all the time. Someone comes up with the smallest thing that no one ever thinks will take off, and then it does. So when you're doing your logos, so for, even on that tent, like the little image that we have on here, everybody has some logo or designs that they go in their business. Anytime you're doing that kind of work, even if it's somebody you're just hiring to do it for a small amount of money, you want to make sure that you have even a basic contract in place to make sure you've protected to spell out what that is. Okay? The need to publish it. So what do I mean by publishing? Publishing means making it public. It doesn't mean, for example, if I'm an author, publishing it through a publishing house. Okay? Even before the days of self-publishing, I could write a book. My dad is actually an English major, okay, but he's a musician. There's many things my dad has written that have never seen the light of day, but he's the author of it. He didn't have to publish that. He could get a copyright on all of those things, even though no one ever paid him money for that. Okay, so when you go to register a copyright, they'll ask you, did you publish it? And that's what they're asking. When you've published it, it helps because if you've published something, you have a time, and I can show a time that I did it. This gets back to the issue before that, the first in time. How do you know you did it? If I wrote something and I kind of left it on a shelf, or I left it on my computer, and now someone stole my story, for example, the famous story that came out a couple of years ago where a person claimed that someone stole Harry Potter, or they said that they stole Harry Potter from them after she was a billionaire, right? I'm like, well, of course they stole it, right? But she had published the books. They're like, when did you publish it? But imagine if, as you know her story, she was homeless at the time she actually wrote that. Imagine if she had just had that in a backpack and no one ever saw it. She'd be fighting for that. So what happens is, for an artist, If they have written something or your manuals and that, you want to have them copyrighted because now you have a date stamp that says, I created it on this date. You've now registered it with the U.S. Copyright Office, and now you have that time stamp, right? And now there's no question that you wrote it, okay? Even if you never make money on it, because you don't have to make money for it, okay? So finally, and we're going to talk about damages on the statutory side now. So common law, why do you not see a ton of common law copyright suits? Because there are a lot of starving artists. And in a business, it's not where you make your money. Even when you're doing trade manuals and stuff like that, you're not making money on the manual itself. It's just a marketing tool. You're making, right? You're looking at it. You're like, I just put this manual together. Fine, I'll just create a brand new manual. Okay. As opposed to if someone stole your business, if they went and took your customers, you get, that would be an effect, right? So the common law damages are like minimal. That's why it doesn't do anything for you. It's what can you prove? What if you didn't lose a single customer? What if someone took something that you put all this time in there, your customers are so loyal to you that they never left? You suffered no damages. You can get $1 damages in court and you won, but you lost completely, right? So if you have anything protectable, I'm telling you about common law, it exists, you have a right. You would put that little C symbol, but it's about worth what it's written on, okay? All right. So the U.S. Copyright Act is where it's at, okay? The Copyright Office, the fees to actually register a copyright are about $65. That's your actual cost. Now, of course, attorney's fees are more than that. So any person can actually register their own copyright if they understand it. You could right now go on the usco.gov and you could actually register everything that you have. So when people are starting out with businesses, at a minimum, they should be doing that, okay? There may be some services that do it. We obviously charge a legal fee, and the idea is we want to make sure it gets done right. But if you are comfortable, and sometimes people, especially if they're in the music industry and some other things where they feel comfortable with it, you can do that, okay? When you get it registered, okay, I'm gonna actually drop to the bottom and then I'm gonna flip back up. It's good for your life plus 70 years, okay? For 70 years, okay? So you don't have to worry about once you've copyrighted stuff, you're like, oh, well, you know what, I've been in business for 50 years. It doesn't matter. It's gonna be, it could be around for 100 years, okay? When you read about things in the public domain, the artwork and stuff like that, it's because the authors were around, like the 1800s and stuff like that, and eventually becomes public. They have to then renew their copyright, okay? And that's why you will see subsequent editions of books, because every subsequent edition becomes a brand new copyright. When you add new content, there's sort of a tricks to the trade, that's why you'll do that, okay? So copyrights give you all of these different protections. So it's your actual gross profits, okay? So what would you make? So an artist, what are you selling a painting for, okay? If it's an author, what are you selling it to publish those? For someone who's in a trade where, for example, you're like the manuals and stuff like that, catalogs, let me just say, let's take a catalog as a perfect example. What are your profits off a catalog? It's the sales you make off those catalogs, even if it's on there. So for example, someone goes on there and they say page after products, and then it will link you to payments. So what you will say is, in a given year, my gross profits are $1 million on the sale of these products. And they will say, well, no, that has nothing to do with this content that you have. No, it does. You go on my website, this content is there. This is how they know about it. They see the pictures and all that, okay? So by having that ability to quantify it, you have it there. Or statutory damages. So why the or? Because imagine if I don't have a true loss. What if it's a situation I can't show I lost a single customer? Well, what good would the Copyright Act be? We'd be right back at common law. So the or is the statutory damages. $750 is the lowest amount you can get, okay? So that's someone who really didn't lose anything. But it can go up to $30,000 and another $200,000 to $150,000, okay? What it does is it allows judges to do wiggle room to compensate you for what the loss has been, okay? It's doubled if there's a licensing violation. So licensing, if you have anything that is, so when you think about, for example, a franchise, right? They may license their name and manuals that they use. So if you've ever been involved in a franchise situation, you know that they'll give you like sort of how do you start up your business. They give you a manual yay thick and they say you can't steal it, okay? That's a license. So anytime you're letting somebody else use it, if in your business you retain ownership, but now you want to open up a business in Florida. That's very common, where people don't want to franchise, but they want to license the idea. They have a great name, we have a great idea, you'll use my name on the side of your truck or whatever that is. That's a licensing. It doubles those damages, okay? For up to 3 years of your profits, okay? Now, strategy is, what is the 3-year period? It's from the time of the breach, okay? So many times people are going to take your stuff when you're at your height, not when you're at your bottom. So you can imagine usually the 3 years damages you're talking about are going to be fairly significant if they've taken the time to go after you, okay? And you can get reasonable attorney's fees in the court's discretion. Almost every statute that has attorney's fees is discretionary with the court. However, when it comes to things like this, so in the employment setting with discrimination and the like, they have fee shifting. When you have what is called qui tam litigation, which is where you get like whistleblowers, and in the issue of intellectual property and copyrights and trademarks, it's discretionary, but they're always awarded, okay? Because in order to win these cases, even though technically it's gotta be willful, so if you think of like a willful child, so think about in the business setting, someone who did it, they kind of knew what they were doing, they tried to get away with it, the judges are going to award the fees, right? There's actually where your penalty is. It's not supposed to be penalty, but that's where you're going to suffer. Because imagine if you drag somebody through a 5-year lawsuit, their legal fees aren't going to be 10 grand. Right? It's going to be hundreds of thousands of dollars. So you start stacking these up, and you can imagine what was a small company could theoretically get several hundreds of thousands of dollars in damages, okay? And then the big one is the injunctive relief. And we're going to talk a little bit later about injunctive relief. Injunctive relief means you can shut down what they're doing immediately. Say you got a website, it's got all your content on there, they rip it off, that happens a lot. And you're like, hey, they're using my stuff, what can I do? If you have a copyright on that website content, you go into court and you immediately seek for a shutdown of that website. It means it takes it down. Yes, but Judge, I spent so much money. They're like, I'm sorry, Mr. Smith, but you just violated their rights, you're shut down. And as you know, you shut it down for any period of time. That's lost revenues, and it allows you to force a settlement, okay? So all those damages are available. So you saw from the common law, got nothing, and now look at all this. We took a case that might have been worth $1,000 and we turned it to several hundreds of thousands of dollars, okay? That's why you would hire an attorney to be able to do the copyright for you, because you want to make sure that what you've protected is proper. That's really, our fee is nominal. We make more money on litigation, right? So it's better to come in and do it right from the transactional side, so that hopefully when you get to this point, you're just like, let's go, let's go, let's go.
Thank you again for watching this informative session. If you have any questions about what you just heard, or want to contact us for legal or business consulting services, you can reach us at 630-230-8434 or email us at kmclaughlin@ma-lawpc.com. Have a wonderful day.